Welcome to today's webinar, Changes to OSHA under the Biden administration. I just have a few announcements before we get started today. Today's presentation is in partnership with Fisher Phillips and will be presented by Travis Vance. If you have any questions, please enter them in the question box and Travis will get to them. If you would like to view or register for more COVID-19 webinars, you can go to hrsimple.com/events. Today's presentation is hosted by HR Simple. HR Simple provides state and federal employment guides. Each manual goes over a plethora of topics such as employee documentation, I-9 forms, vacation policies, and more. Today you can use code COVIDwebinar30 for 30% off any HR Simple product. And before we get started, just wanted to learn a little bit more about Travis. Travis is a partner in the firm's Charlotte office and co-chair of the firm's Workplace Safety and Catastrophe Management Practice Group. Having gained a reputation as a professional and aggressive advocate for his clients, Travis has emerged as a thought leader in the field of workplace safety. His writing and interviews are followed closely by experts in the safety arena and have been featured in premier publications such as Bloomberg Law, Business Insurance, The Washington Post, EHS Today, and The Wall Street Journal. He has tried matters across several industries and various subject matters, including employment litigation, business disputes, and matters prosecuted by MSHA and OSHA. And on that note, I'm going to hand things over to Travis so we can go ahead and get started.
Okay, thank you so much, Anna. I appreciate that. Does the screen look good there?
Yes, it looks great.
Perfect. All right, well, good afternoon, everybody. I hope everybody's doing well. I know that we're still in a challenging time, and it might be the toughest time of this extremely unusual pandemic. But today we're going to talk about kind of where we are, where we think we're going to go with respect to OSHA enforcement, and why that's important to your company. So just keep in mind that we're going to talk about not just sort of where we are now, but what the future is going to look like and how you can be prepared for those changes. And specifically, what we're going to talk about is sort of what the current the state of workplace safety is with respect to COVID-19. What kind of enforcement are we seeing? What kind of best practices are out there for employers to engage in order to keep their employees safe? We're going to look ahead. How's workplace safety going to change with the change of the presidential office as a result of the election, with Joe Biden taking over as the president in January, and what's his administration going to look like, and what's his administration, how's he going to view OSHA, and how's enforcement and other things going to be conducted during his time. And then lastly, we'll talk about, how can you be prepared for these changes, talking about mindset of the management of making sure that you are keeping employee safety at top of mind and making sure that's the paramount concern in your workplace, and best practices to keep your folks safe. So we're kind of, where are we now with respect to COVID-19 and workplace safety? My sort of journey through this is that I was at an in-house council conference back in February in Fort Lauderdale. It was in person, so they can imagine how long ago that was. And we had 65 or 70 in-house lawyers there, and we said, who wants to hear about this coronavirus that had really shut down the stock market and was starting to arrive in California at that point? And everybody raised their hand, and I was the only workplace safety lawyer from our firm that was at this conference. So that meant that I was going to stay up most of the night and get ready to do a presentation at 7:30 the next morning. And I did just that. That was on February the 28th. That was before it was even considered a pandemic. And so that was my first presentation about the pandemic. Since then, I've done about 55, I think, presentations about the pandemic and talked to over 600 different companies about the coronavirus. And it's been a very interesting journey. For me, it's been very challenging and rewarding. And also just as a reflection on how important human life is and health and safety. I've dealt with, employee deaths of 23 and 37 and 42-year-olds. So it's been a very interesting year and unique, and something that we'll probably always remember, but hopefully will be behind us sooner than later. So what's OSHA doing with respect to COVID-19? Federal OSHA has not adopted a COVID-19 standard. There's no COVID-19 federal OSHA standard directly on point. There's other standards such as personal protective equipment that we'll talk about, bloodborne pathogens, hazard communications for chemicals. Those are all standards that are on the fringes with respect to COVID-19. And then, of course, we have OSHA's general duty clause. That's the generic requirement that you keep a safe work environment. And so what OSHA can do, and they've already announced this, if you're not keeping a safe workplace, for instance, if you're not following local or state shutdown orders or guidelines or the CDC's guidelines, then OSHA can come in and use the general duty clause to cite you, even though there's no COVID-19 standard and there may not be a specific standard directly on point. So just keep that in mind. If you don't want to follow the CDC guidelines, you're saying they're just guidelines, OSHA can use that as a violation of the general duty clause. Trump's administration announced that. Really haven't seen a whole lot of those, but that's something that they say that they are willing to do. Other citations that we're seeing, mostly respirators and PPE. So a lot of folks are confused about what N95s are. Those look like dust masks that you could buy at your hardware store. But if it's an N95, a filtering face piece, OSHA considers that to be a respirator. So if you require your employees to wear those, they have to have medical evaluations, fit tests, and other things that are required under OSHA's respiratory protection program. Even if you make it voluntary for them to wear an N95, there's still things that you have to do under OSHA's regulations. So just keep that in mind. That's one of the ones we're seeing a lot of. PPE, whether it's gloves or goggles or something else that you may have your employees wear, whether they're cleaning something, cleaning a surface, disinfecting, maybe they're administrating COVID tests. Do they have the right PPE on? Those are all things that OSHA is taking a look at right now, but mostly focused on respirators. So if you're using N95s in the workplace or a different type of respirator, just be aware of the various requirements that OSHA has with respect to the use of those items. So record keeping and reporting is another big thing that we're seeing with respect to OSHA. So if you're on the call and you have to keep 300 logs, that's for most employers that have more than 10 employees, unless you're otherwise exempt. You have to keep track of the injuries and illnesses in your workplace. And OSHA said back in April and May, and we'll get to that, that if it's a work-related COVID-19 case, then it needs to be recorded on your OSHA 300 log if it otherwise meets the requirements like treatment above and beyond first aid. So the guidance from OSHA under the current administration started back in April, and the April guidance said that you only had to do a work-related investigation in most situations if you were in one of three categories of employers, and that was healthcare, emergency response, and correctional institutions. But in May, they reversed that course and expanded that to all industries. And really, it boils down to a three-step process. I see that my photo art there has covered it up, but it's essentially three things that you need to do. You need to ask the employee, where do you think you got COVID-19? The second thing you need to do is you need to ask the employee, is there anything outside of work or anything inside of work that may have caused you to get COVID-19? You'll be surprised at some of the responses you get. Sometimes they'll say, oh yeah, I was at my cousin Bubba's barbecue and that's where I got COVID-19. Or sometimes they'll be adamant that they got it at work because there's no way they could have gotten it anywhere else. And then finally, you need to assess the workplace. Where do you think the employee got COVID-19? Did he deal with a coworker or work next to a coworker who had it? Did he deal with a member of the public who had it? But you need to do those three steps to determine if the COVID-19 case is work-related. If it is work-related, it needs to go in your 300 log. If it's not, then you just have a memo and put it in the file. Most of the time, you have enough doubt as to where it occurred to not put it on your 300 log, but OSHA is going to make sure that you did that investigation if there is an inspection. So with respect to reporting accidents, OSHA came out with a clarification in September, but it's very rare that you would pick up the phone and call OSHA. That's different than recording an OSHA case on your OSHA 300 log. So if Johnny, I always pick on Johnny as being the employee with COVID-19, but if Johnny gets COVID-19, he is hospitalized within 24 hours of leaving work, then you would call OSHA, but his hospitalization has to occur within 24 hours of him leaving work. If he's hospitalized 4 days later, 6 days later, then you would not have to call OSHA in almost every state. Now, there are states like California that would require you to report that hospitalization, but in all the federal states and most state plans, if Johnny is hospitalized more than 24 hours after any exposure at work, you don't have to report it to OSHA. You only have to put on your 300 log. And the other thing to remember is if Johnny passes away within 30 days of him being at work, then you would need to call OSHA and put that on your 300 log. If he dies 31 days later, you only record it on your 300 log, but you have to report it if it occurs within 30 days of an exposure at work. Best practices with respect to the companies that I've talked to really are taking a look at, how are we going to sort of redo everything that we do in the workplace? Is there any way people can work from home? Can we separate people? Is there any way we can limit the number of people in the same room at the same time? So this is going to be around for a while. Looking into 2021, if you don't have a written COVID-19 response plan, you should. You can't train your employees unless you have that. And if OSHA shows up or you have a workers' comp claim or a third-party claim, if you show them that COVID-19 response plan, it shows your commitment to safety, what you're doing to keep your employees safe. So just keep in mind with respect to all your protocols and procedures, how can you reinvent those to keep people safe, keep people distanced from each other? Because frankly, the only way to really stop the spread of the virus is to keep people away from each other. And if you can reinvent, reimagine your policies and procedures to do that, that is the best approach. We're going to see more and more shutdown orders begin to reemerge. North Carolina just said that they put in place a curfew between 10 p.m. and 5 a.m. And in that case, you might have employees that are stopped by police officers at midnight if they're on their way to and from the third shift at your facility. So you probably want to have a letter, give them a letter to document that they're going to and from essential business or critical infrastructure on their way to work. So just keep that in mind. Other things to take a look at, make sure you have PPE. Do you need gloves, goggles? Face coverings, OSHA has not said those are PPE in most situations, but you should have those in place. How are you going to clean and sanitize the workplace? How often is that going to occur? Is it going to be done internally or an outside vendor? What's your protocols for screening employees and guests? Do you have signs up that tell them that they're going to be screened? Who's going to do it? And how are you going to keep those people safe? So if you have Sally from HR taking temperatures, what kind of training does she need? Does she need to be trained on an exposure control plan because of the bloodborne pathogen standard? Does she need gloves or goggles? How are you going to do that? Transportation safety. If you transport people in a van, if you have a carpool system that's sponsored by the company, how are you going to clean and disinfect the vehicle? How are you going to keep people separated? And then finally, and most importantly, how are you going to train the managers and supervisors who are going to help you roll all this stuff out? One thing I've learned during the pandemic is that communication is absolutely key, and how you communicate to your employees is crucial, because if you're not a good communicator and make them feel at ease, they're going to be scared, concerned, not want to come to work. And your managers need to be trained on how to communicate your policies to the employees, because if they're not trained, if they don't have a good bedside manner, then they're not going to be sending a message of confidence to the employees, and it's going to cause greater concerns. So just keep that in mind. Now, kind of pivoting here, what's workplace safety going to look under the Biden administration? How is it different, sort of with that summary, that introduction of where we are right now? So one of the big things that just a simple change that we're going to see is there's going to be a head of OSHA. There's going to be an assistant secretary of labor assigned to OSHA. Okay, under Trump there never was one. Scott Mugno from FedEx was nominated, and he withdrew his name in 2019. But we never had an assistant secretary of labor for OSHA under the Trump administration. So what that causes is that you don't really have someone guiding the ship as to what your enforcement initiatives are and things along those lines. With respect to MSHA, the mining safety side, There was an assistant secretary under Trump, and that really caused enforcement to go down significantly. Where with OSHA, we had a lot of the career government officials that were running OSHA, so it was really kind of status quo. It really didn't change a whole lot, other than the fact there were no new OSHA rules. But we'll talk more about that, why that was important. But with really under Trump, OSHA just kind of stayed where it was. Under Biden, we feel like they definitely will fill that position for assistant secretary. And that's what you will see is there's going to be more activity from the agency, whereas there was not much at all under Trump. Some other things that we have, we believe will happen is that OSHA has advisory committees that meet with the folks in the agency and kind of guide them on issues in that particular industry. What are safety concerns that they have? Is there a new standard or rule that needs to be done? And those committees basically have been dormant for the last 4 years to help guide the agency in safety enforcement. So we expect Biden to fill those roles with folks from the industry that will represent both the employer side and the labor side. So you'll have folks that will talk about, here's all the different issues that we're seeing. That could lead to additional rulemaking, maybe new standards that will be developed, but we see that as a possibility. So we talked about federal OSHA currently does not have a COVID-19 standard. There is no standard directly on point for COVID-19. You have seen that in some states. Virginia was the first. California just adopted theirs a few weeks ago. So some states that have state OSHA plans have done that, but nothing from the federal government. They've indicated that they won't. They've been relying on general duty calls and PPE, like respiratory protection program standards, things along those lines. But I think that an emergency temporary standard for COVID-19 will go into effect probably in the springtime, especially until there's a pandemic. And I think it'll cover things like, how do you report COVID-19 cases? What kind of sanitation is required? What kind of contact tracing do you have to do? Do you have to provide sick leave? That seems to be outside the province of OSHA, but both Virginia and California have gone there with respect to their state OSHA plans. So we think that there will be an emergency temporary standard for COVID-19. And one of the crucial parts of that is a written COVID-19 response plan, a workplace safety plan. So in California, if you're there, you know that there's an injury and illness prevention program that's required. Virginia, if you're in Virginia and have more than 10 employees or 10 or more employees in most industries, you have to have a written COVID-19 response plan because of their standard. And we think federally going forward, you will have to have that written COVID-19 response plan. And for the reasons I stated earlier, you should already have that in place just to protect your workplace, protect your workers, defeat and hopefully avoid any citations or lawsuits. And if you have that in place, then you'll be ready for this, but we definitely see that's coming down the road. So with respect to enforcement initiatives, we think enforcement will definitely go up with respect to the number of citations and the types of citations. So there's largely 4 types of citations that are issued. There's serious, which is kind of your run-of-the-mill OSHA violation for things like PPE, lockout, tagout, machine guarding, things that could cause a serious injury or lead to death. Those are serious citations. Then you have other than serious. Those are the ones that are largely record keeping, things along those lines that could not cause serious harm or death. And then you have repeats, which the employer has gotten more than one citation within a certain period of time. And then willfuls, which is essentially intentional or reckless disregard, that type of behavior from the employer. So with respect to Biden, they're going to be short-staffed in 2021 and probably 22 because the number of inspectors is way down. But that doesn't mean they won't be more aggressive with issuing higher penalties on their citations, more repeats and willfuls, expanding the scope of inspections. That's something they were doing back under the Obama administration, and I think they will continue. They'll pick that back up under Biden, even though they don't have the numbers. They can have levied larger penalties for each citation for the inspections that they do conduct. So, Biden will continue to expand enforcement with respect to reporting and recording. in deaths and infections for COVID-19. I think that, you know, California has basically a requirement that if it's related to or connected to the workplace, you have to report it. The feds may try to expand the reporting or recording of COVID-19 cases and not give employers as much wiggle room that they have under that three-step plan, that three-step analysis I mentioned. I think the Biden administration will aggressively enforce record-keeping issues with respect to COVID and whether or not it's reported to OSHA, because those types of citations just don't look good in the press for employers if you knew about something and you didn't report it to OSHA. So I think they will try to make examples of certain companies that don't record or report COVID-19 cases and really try to make employers record those instances just as a way to hopefully force employers to step up their COVID-19 training and response plan and cleaning and sanitation. We just feel that that's something that will probably happen. And then on the MSHA side, if you have a quarry or if you have any facility subject to mine safety, could be a surface mine, we think that enforcement will go way back up to what it was under Obama, which was much more aggressive as well. Other things that they will do is, you know, the Biden administration is going to look to protect public sector workers, you know, provide additional training and education on the consultation side. So OSHA has sort of a wing of just trying to help employers comply without enforcement, really educate and reinforce the resources that the government has to help employers outside of an enforcement context. Work with FEMA on the expansion of the supply and availability of PPE, and then other government agencies with respect to testing. We really think that testing is going to be you know, used more by employers. You know, it's not just a temperature check, but, you know, are you COVID-19 positive? Use a rapid response test before they go into the workplace. In California, right, with their new Cal OSHA regulation, with, you know, 3 or more positives within 14 days, you essentially have to test everybody at the workplace. And so folks in California are going to be testing everybody for a long time is my prediction on that. So I think with respect to the feds, they're going to really focus on testing and try to make it more accessible to employers. And it might be a situation where you might have to be testing your employees if you have multiple cases in the workplace. So, you know, how should the employers prepare for 2021 and this new administration? Really, it's a good time to really sit down and take a look at the CDC guidance and state and local guidance. It's really rapidly changing every day, every week. Again, I keep focusing on California, but they've adopted a couple things out there in the last couple of weeks where, you know, it's in effect. The OSHA regulations in effect now. There's big changes January 1st on notice in California. So if you have facilities in California, I'd highly encourage you to reach out to council to get that information because it's drastically changing. But here are, just from a federal standpoint, having talked to all these companies, these are the 4 ones that I keep getting time and time again. Is returning. The first misunderstanding is that employers were, you know, requiring someone to quarantine for 14 days, and then on the 5th day they would get a negative test and they would let them come back to work. Well, you can't do that because the virus is, you know, has an incubation period of 14 days, so someone can develop it on day 10 or day 11. Now, I will tell you, the CDC last week indicated that it was going to roll back the 14 days to 10 days, or if you had a negative test on the 6th or 7th day, then you could come back after 7 days. But if you look at the CDC's website, I joked with folks that they've kind of rolled back the rollback because they still recommend the 14 days, but they say that state or local health officials can do the 7 days or the 10 days. So I would just be aware of that. It's not really been a significant change with the quarantine period. The federal guidance is still 14 days, even though they have given the green light to the states and local officials to go to 7 and 10 days. So just be aware of that. If you've been using 14 days, you may not want to change it overnight because it's something that your employees are aware of and they may be alarmed if it's changed. The second thing is calculating the quarantine period for someone who's exposed to a household member. So the quarantine period starts on the last date of exposure. So if someone's living with a spouse who has COVID-19 and the spouse is sick for 10 days before they're released, then your employee, if they're within 6 feet of that spouse for every day for 10 days, their 14-day period doesn't start till the last day. So it would technically be 24 days. That's a common misunderstanding. Not notifying employees of a confirmed COVID-19 case. It was part of this new Biden emergency temporary standard that I think we're going to see is going to be that you have to notify employees of a COVID-19 case in your workplace. Our law firm's been keeping track of all the lawsuits related to COVID-19. This is the #1 type of lawsuit that the employer did not tell the employees that one of their coworkers had COVID-19. Very crucial. There's a 4-step plan that we have gone over at our firm on the things that you want to do. The last of which is that you want to make sure that you notify the coworkers. Just keep that in mind. And then the last one is that a lot of employers think that if you're wearing a mask, you haven't been exposed to COVID-19. Or if you're just wearing a regular face covering, a surgical mask, you are still supposed to be quarantined if you've been within 6 feet of that person for 15 minutes or more. That's cumulative 15 minutes in any 24-hour period for the time period of 48 hours before the infected person had symptoms or later. That's what we call the 6-15-48 analysis that you may have seen. That's taken the CDC's guidance and really bringing it down to a numerical acronym that you can remember. But that's the 6-15-48 analysis. Those are the employees that have been within 6 feet of the infected worker for 15 minutes or more for the time period of 48 hours before they had symptoms or later. Those folks would need to be quarantined for 14 days under most situations. It's just something good to keep in mind. So going back to the Trump administration, as I noted, the current number of OSHA inspectors is at its lowest level in the 449-year history of the agency, down to 761. In his campaign documents, Biden had had noted that the number of inspectors should be doubled. So that's not going to happen overnight. There might be funding issues. They all have to go to Officer Training Institute up in Chicago. OSHA calls that OTI. They have to be trained. And so it could take up to about 18 months before they have these folks out in the field. But you can expect, especially during the last 2 years of the Biden administration, there will be more OSHA inspectors conducting inspections. And with respect to some of the rules that were adopted under the Obama administration, of course, Mr. Biden was vice president at that time. OSHA is just not enforcing these right now, but they could be resurrected and they could start enforcing them. One of those is the electronic record keeping rule, which basically said that some employers, especially if you had 250 employees or more at a single location, would have to report injury and illness data to the government. Well, OSHA rolled that back in 2018, I believe, and said you only have to do the 300-day summary information if you met those criteria. But we believe that the Biden administration will go back and say it's not just 300, but it's also the 300 logs with redacted information will have to be uploaded to OSHA's website. So just look for that. Be prepared for that. It's a good time to redo record keeping training in your facility if you haven't done so. With respect to general duty clause citations, to the extent there's a time period where there is no emergency temporary standard for COVID-19 in place, the Biden administration, like we said, can use the general duty clause. Trump said they were going to use it. It hasn't been done really yet. But we feel like if you violate the CDC guidance or local or state ordinance, that the Biden administration, OSHA under the Biden administration, will issue more general duty clause citations if they feel like there's a violation of the general duty clause. So what is essentially the general duty clause with respect to what OSHA has to prove? They essentially have to show that you violated the general duty clause because you did not keep a safe workplace free from hazards that were recognized. So how can they be recognized? There's a whole variety of ways that they can be recognized, but if they're part of literature or guidance from a different agency, such as the CDC, then OSHA is going to take the position that it's recognized and that the employer should have known about it. So if it's published by the CDC, OSHA is going to say that that's a recognized hazard and the employer can be cited for it. Other things that we think that they will do, not just the emergency temporary standard, but back in the in the Obama administration, during the H1N1 pandemic, OSHA actually drafted an infectious disease standard. Now this standard is a permanent standard. It would be in place forever until repealed, but it would cover not just COVID-19, but it would cover any pandemic we may get in the future. It's really going to focus on health facilities and other high exposure workplaces, but this would be separate from the emergency temporary standard for COVID-19, but basically cover all infectious disease and be in place for any pandemics that we get in the future. We think that's another thing that the Biden administration will likely do. May take him a while, but this is completely separate from the emergency standard. As you may know, there's about 25 or so of the states in the country are state OSHA plans. They enforce the OSHA Act themselves. The balance of the states are enforced by the federal government. Now, some states like North Carolina and South Carolina, they don't have COVID-19 standards. They haven't even increased the maximum penalties for their citations, which were adopted originally back in 2015-16. We've seen states like Virginia, Michigan, California, and Oregon have adopted emergency temporary standards for COVID-19, even though the feds haven't. So the states have kind of been doing their own thing under the Trump administration. There's not been a lot of coordination there. Well, we call it coordination, but really what we saw under the Obama administration is that the federal government was kind of forcing the state plans to be more aggressive with respect to enforcement and making sure and monitoring that they were being more aggressive. So we think it will go back to that after Biden takes office. We think that the Biden administration will really force the state plans to be more aggressive. They'll try to get them to increase the penalties, the maximum penalties. They'll try to get them to adopt a COVID-19 response emergency temporary standard. But we think that the feds will be very aggressive to try to get the state plans to be more on the enforcement side. And I will tell you that I have heard some of the names that have come up with respect to who's going to run OSHA, and the ones that I have seen and that I'm familiar with are they're very union friendly. They're very heavy on enforcement. They're very heavy on sort of public shaming of employers that have hazardous workplaces with press releases and things along those lines. So if the ones that I have heard become the head of OSHA, then I think that we're looking at a very aggressive agency during the next 4 years, and they will attempt to make the state plans as aggressive as well. Now, one of the other things, and I think this one is, out of all the things we're going to talk about today, this is the most important thing to keep in mind, because I think a lot of people have forgotten about this one. But back in 2016, OSHA adopted a 3-part anti-retaliation rule that really changed a lot of the things that you can do at your workplace without getting cited. You may remember it because a lot of people remember it for the drug testing rule. So it really has 3 parts: drug testing, reporting accidents and injuries, and safety incentive programs. So for drug testing, OSHA says you can't just drug test somebody because they report an accident, right? You need to have some sort of reasonable suspicion that drug or alcohol use led to the accident. Then you can drug test them, all right? So blanket drug testing policies, OSHA was trying to get rid of those. Now, before you freak out about this, you can still do DOT drug testing or any other statute that allows you to. You can still do drug testing if workers' comp in your state allows you to do that. You can still do drug testing if you get a discount on your insurance, workers' comp insurance, pursuant to a state state statute that allows you to have a drug-free workplace program that gives you that discount. So it has a lot of holes to it. But if you're in a state like North Carolina, for example, that doesn't have any of those exceptions, then you really need to slip over to a reasonable suspicion drug testing for post-accident. So if Johnny shows up, slurring his speech, walking across the parking lot, and he's fumbling around, you're gonna drug test him. So you take that same analysis and you apply it to post-accidents. That's a really easy fix, and I've got some language I'd be glad to send to you. So that's the big one. The second one is if you fail to report an accident, or if you punish or discipline an employee who doesn't report an accident immediately, you can't terminate that employee, because OSHA wants you to give them a reasonable amount of time to report it. So they want you to give the employee 8 hours or until the end of their shift to report an accident. The reason for that is because if people don't report it within an hour, maybe they were at the doctor or something like that, they will discipline for that, and they'll just stop reporting accidents. And then the last thing is that employees don't want you to, OSHA does not want you to have an incentive program based on the number of injuries reported. So in other words, if you give everybody a $250 bonus if they have an accident with no recordables or no reportable accidents, then what do people stop doing? They stop reporting them to you. So they want you to focus on what they call leading indicators, which are things like successful audits, reporting a near miss, serving on safety committees, coming up with ideas to improve safety in the workplace. Those are all things that improve safety in the future, as opposed to just the number of accidents that have occurred in the past. So those are things to think about as well. Again, this is a rule that OSHA adopted in 2016. It has not been repealed. It just has not been enforced. So I think employers need to be ready for this one. There was a document that came out in 2018 that talked about the drug testing issue, but it didn't repeal it. It just kind of gave a clarification on it that said you could still do drug testing like random and things like that. So just keep this in mind, and if it's probably time to go look at your drug testing policy and see if it would pass muster, because OSHA can actually cite you for this now, and they just haven't been doing it under the Trump administration. So how do you get ready for this? If you're familiar with any of the ISO safety standards, especially the 45001, which is a new one, it's really a top to bottom approach to keeping people safe. So when you're going into an administration that's going to be heavy on the enforcement, you really need to figure out what your strategic plan is. What are you going to invest in safety? What is your budget? How are you going to keep track of what it's going to cost you to do certain things from a safety standpoint? What it's going to cost you if you don't do things from a safety standpoint? So what's your mission, your vision? What goals do you have? Who's going to keep track of those goals? Who's going to keep track of how are you going to meet them? Do you have metrics that you're going to meet? How are you going to make sure that the managers are buying in? If the managers are not buying in, then it's really not going to be effective. So it has to be a top to bottom approach. How many accidents and injuries are acceptable to the company? How many that occur? I mean, is it they want 1 a year, 9 a year, 10 a year? What's acceptable? So really figuring out what the goals are, how to keep people safe, top to bottom, changing your safety culture so that you don't have to worry about OSHA inspections. You don't have to worry about higher penalties and repeats and willfuls and things like that, but really figuring out how we're going to keep people safe and avoiding OSHA inspections. And part of that is your training. Training is crucial, especially if you're in an industry that has high turnover. Maybe you have, if you're in food processing or manufacturing, you have a lot of people coming through the door. You have to train new people all the time. How are you going to make sure that they are up to speed on your workplace safety policies and procedures? What are your metrics to get that done? Do you have calendar reminders to make sure all your employees are trained, whether it's a 3-year certification on forklifts or another annual certification like lockout, tagout, machine specific procedures? How are you going to keep track of that? How are we going to have, who's going to keep track of the metrics? Who's going to be responsible for that? Those things are all very crucially important. Now we have a few minutes to go to questions before I turn it back over to Anna, but I did want to let you know I've got a few things I'd be glad to send to you if you want to email me. The first one is that reasonable suspicion drug testing language that I mentioned. I've got an article that I did about that 2016 anti-retaliation rule. If you'd like to take a look at that. And I've also got a couple of articles about, or just documents about what to do if OSHA shows up that you can take and use and train your employees on. If you email me, it's on the screen, tvance@fisherphillips.com. I'll be glad to send that to you. And we've got a few minutes for questions. So if there's any questions you may have, just feel free to put it in the chat function. I'll turn it back over to Anna.
All right, our first question is, if a COVID case is determined to be work-related and reportable, are days the employee is at home recovering count on the 300 log as lost days?
Yeah, if they're not at work, because of the work-related COVID-19, then those would count as a lost day, just like if they had an amputation or some other type of injury.
And then a follow-up to that question, what if they can work at home?
Yeah, if they can work at home, then they're not going to be doing the same function. It's not restricted. If they can do the same function at home, then you can cut the days off at that point, as long as it's not restricted or transferred, because it can be not just days away, but it can also be restricted work or transferring them to a different job.
Okay. Our third question is, how do you think OSHA would affect the requirement of a vaccine in the workplace?
Yes, I think in most situations, OSHA is not going to cite you for the failure to mandate vaccines, unless you're in a situation where a statute, let's say like a statute says that healthcare workers have to have the vaccine, and then you avoid that statute, then you could get a general duty clause citation. But if you're in a bank or an office setting or something along those lines, and you don't mandate the vaccine, I think the chances of you getting cited for that are going to be very low.
And I think that's all of the questions we have for right now. I don't know if anyone will give everyone a couple moments to submit any final questions. I think those are our 3 questions for today.
Okay. Well, if anybody has any questions.
We got one last one just in.
Okay.
Do the required COVID notifications include confirmed, suspected, and exposure encountered outside the workplace?
It would mostly, for OSHA, for general OSHA purposes, you only have to report to OSHA a work-related COVID-19 case. So it would be work-related. If it got outside of work, it would not be work-related. That is the general rule. So if it's not work-related, you don't have to record it on your 300 log, and you don't have to report it to OSHA.
Okay, great. I think that was our last question for today.
Okay, well, thanks everyone. Everybody stay healthy, and hope you have a great holiday season.
Thank you so much, Travis.
Thank you.
All right, everyone. Up on your screen right now should be my email, anna@hrsimple.com. If you do have any additional questions for Travis, I'd be happy to forward those along to him. If you do have any general questions about the presentation, slides, anything like that, those will be sent out tomorrow, but I'd be happy to answer anything before that. So you can go ahead and use that email to contact me. And then this webinar was SHRM accredited, so the credit will be on the screen. You can go ahead and copy that down. And if you have any questions about that, please feel free to email me. All right, well, thank you again, Travis. Thanks everyone for coming out today. Have a great rest of your Wednesday.